Hello, all. Good day. We can officially begin the session now. And I am Margaret Jackson, the co-director of the Frieda Center here at SFU. And along with Dr. Yursich, the two of us will be coordinating the Awareness to Action webinar today. And we've been looking forward, actually, many people have been looking forward to this webinar entitled Hearing Women's Voices, the 2025 AB versus Henry case in the BC Supreme Court. But before I introduce the speakers and the topic more fully, I would like to provide the SFU land acknowledgement. So the Frieda Center respectfully acknowledges the Musqueam, Squamish, Tsleil-Waututh, Katsi, Kwetlam, Quaquate, Kwantlen, Semiahmoo, and Tawasan peoples on whose unceded traditional territories the SFU 3 campuses reside. Okay. So, hearing women's voices. We are actually most fortunate today to have with us 3 key participants to discuss the AB versus Henry case and its significance for the justice for women. I'll first provide brief introductions and before going on to consider some of the other content. So, Dr. Emma Cunliffe is a professor at the Peter Allard School of Law and the principal of Green College. That's an interdisciplinary academic programming space and graduate residence at UBC. She previously served as the Director of Research and Policy for the Joint Federal Nova Scotia Mass Casualty Commission, 2020-2023. Her research explores the perpetuation of misogyny and other forms of bias through legal fact-finding, particularly in cases involving gender-based and sexual violence and those in which women are themselves accused of violence. And as well, we have with us, and welcome you two of the key lawyers for the women plaintiffs in the case. So Kevin Gorley is a partner at Murphy Batista Lawyers, and he was called to the bar in 2008 and has practiced civil litigation in Vancouver since that time. And along with his colleague, Irina Kordic, they were both lead counsel for the plaintiffs in the AB versus Henry case, where they acted on behalf of 5 women sexually assaulted at knife point in 1981 and 82. So then Irina is a managing partner at Murphy Batista Lawyers, and she's been with the firm since 2007 and practices in various areas of civil litigation. So this case, this Henry case, is truly a remarkable case to be discussed by these 3 presenters. And Dr. Cunliffe will be taking the lead in the conversation that follows. But before turning it over to her, I just want to reemphasize that Sarah's going to be monitoring the Q&A box during the conversation and that she can present questions she selected along the way from the Q&A box to the 3 presenters. And also, of course, the presenters themselves as they come to note questions afterward themselves. So very briefly then, just to set the stage here for the conversation, and I like that term, conversation, in this BC Supreme Court decision, Madam Justice Gropper confirmed what 5 sexual assault victims had been saying for 4 decades, basically, that Ivan Henry was the man who sexually assaulted them at knife point in Vancouver in the early 1980s. Justice Gropper found that each plaintiff had met her burden to establish that Mr. Henry is the man who attacked her on the balance of probabilities. And I'll leave it at that because that's sort of an important point to have made for this kind of case. So following in the conversation that we'll have with the lawyers and Dr. Cunliffe, they certainly did learn well, there was a lot that could be learned from this kind of a case, particular case, and from the extraordinary course of the case itself, about not only the Canadian legal system, but also the progress of women's rights to the equal protection and benefit of the law in Canada. So I will turn it over now to Dr. Cunliffe.
Thanks so much, Margaret, for that very generous introduction. It's lovely to see my friends at Quebec and Frida again. Given that you hear from me not irregularly, actually it's our intention today to really let Kevin and Irina take the floor with respect to the very remarkable case that they ran in the BC Supreme Court. And so I'll give a very brief introduction to my own history with this case before Kevin and Irina became involved, but really it's Kevin and Irina's victory and their story to tell today. As Margaret has explained, Mr. Ivan Henry was convicted of numerous counts of rape, as it was then called, in 1983 after a trial in which he represented himself and personally cross-examined the complainants. In 2008, questions were raised about the conduct of the Crown prosecutor in that original trial, and the case was referred to a special prosecutor by the name of Len Doust for reconsideration. Mr. Doust reached the conclusion that there had been prosecutorial misconduct in the case, and as special prosecutor referred the case back to the BC Court of Appeal. The BC Court of Appeal concluded that Mr. Henry had been wrongly convicted on the basis of demonstrable prosecutorial and police misconduct. And Mr. Henry subsequently commenced a civil suit against Canada, BC, the Vancouver City on behalf of the Vancouver Police Department and some named police officers. The complainants who had been sexually assaulted by Mr. Henry reached out to me first in March 2010 to express their consternation at the fact that these legal proceedings were unfolding without giving them an opportunity to participate, and in particular without regard to the question which they rightly considered as important in the context of these proceedings, of whether, notwithstanding the prosecutorial and police misconduct which had played out, it was possible that Mr. Henry was in fact the man who had raped them. I worked with the complainants on and off between March 2010 for about the next 6 years to support them as they sought to be heard within the legal processes that played out. They made a number of applications to the BC Court of Appeal, to the BC Supreme Court. At one time, the Vancouver Rape Relief and the complainants themselves sought to intervene before the Supreme Court of Canada when the case first went up on the question of chartered damages for wrongful conviction. And at every turn, the Canadian criminal legal system denied that they should have what's legally called standing, that is, that they had a legitimate interest in the court's disposition of the question of Henry's treatment. Now, in some ways, this would not have been so problematic if it hadn't been the case that the court inexorably slipped into what I would call an innocence narrative with respect to Henry. In other words, the distance between the proposition that there had been prosecutorial misconduct and police misconduct and the proposition that Henry hadn't committed these crimes really collapsed in the work of numerous judges along the way. Certainly the complainants who were subsequently represented by Kevin and Irina insisted at every turn that this collapse between the question of factual innocence and the question of prosecutorial and police misconduct caused significant harm to them and re-traumatization to them. Unfortunately, their efforts to draw that concern to the court's attention really went unheard for some time. In 2016, I published an article in the Supreme Court Law Review on the Henry case, which was called "Still Seeking a Just Approach to Damages for Wrongful Conviction." The article argued two things. The first is that attention to the question of factual innocence plays a complicated role in the question of compensation for wrongful conviction. But the second was I was really seeking to document the women's efforts to be heard within the process and the ways in which they had persistently been excluded from the court process, despite being extremely articulate advocates and extremely aware of the dynamics that were playing out and of how they were being discredited within the process. I published that article for a number of reasons, not the least of which was that by that time, after 6 years of really trying to find an alternative remedy, I was losing hope that the women would be vindicated through a legal process. And I think that's really a good moment to turn it over to Kevin and Irene.
Thank you. Well, it's our privilege to speak to the Frida Center today, and it was our great honor to act on behalf of these 5 women. Our involvement with them began almost a decade ago now. And it's not the kind of case that, frankly, we would normally handle. At that time in the mid-2010s, when Mr. Henry's charter damages trial was happening, the case was frequently in the Sun. There was W5 on CTV was covering it. There was a book written called Innocence on Trial, The Framing of Ivan Henry. And it just seemed that what was evidently the case was that one side of a complicated story was being told, and that the other side of the story, the victim's side or the victims, what they had experienced was being completely uncovered, and nobody was they weren't having the opportunity to tell that. And so our involvement began, I think, in 2016 or 2017, and I don't think at that point we fully understood the scope of what would be involved, and that it would be ultimately 8 years of litigation and a 3.5-month trial in the early part of 2024. And in fact, that continues. The case is under appeal. And so we do have to be a little careful in what we say today, and there are still sealing and anonymity orders in place. And so we're not able to say anything today that isn't sort of public record, but I think that lots can be learned from what is publicly available. So we'll go through to start with a bit of the background on the case. And Irina, if you want to go through some of that.
That sounds good. Emma has already covered some of the procedural history, but I think it's important to go through it in a little bit more detail as it informs and frames a lot of our discussion that follows. So just to reiterate, in 1983, Mr. Henry was convicted by a jury of 10 counts of sexual offenses involving 8 different women. And all of these assaults occurred between May of 1981 and June of 1982. What was interesting and ultimately became very significant later is that each of these offenses took place under quite similar circumstances. The victims were alone in basement or ground floor suites when in the middle of the night, the perpetrator broke into their homes and sexually assaulted them, either at knife point or with a similar object. In every case, the perpetrator was a stranger to the victim. There were other similarities in many of the cases that were uncovered during the investigation. The perpetrator became known as the rip-off rapist because several victims reported being confronted by a man who claimed that he had been ripped off by someone who owed him money and who lived at their address. And when the victims explained to the perpetrator that he had the wrong place, the man then told them that he would have to sexually assault them, so they would be too embarrassed to report the incident to the police. Now, these comments about victims being too embarrassed to report sexual assault to the police are very disturbing, obviously. They're predicated on the assumption that rape victims feel shame or are somehow to blame for what happens to them. I'm hopeful that with the passage of time since the early 80s and the society's shifting views on sexual assault, the sentiment is at least somewhat different and diminished today. However, unfortunately, as we all know, sexual assault still remains the most underreported crime. Going back to the chronology of the case, on May 12, 1982, Ivan Henry was arrested. He was brought to the police station and he refused to participate in the police lineup. However, the police officers decided that they were going to force him to participate in this lineup. And this resulted in the now infamous photograph, which became inextricably linked to the case and what happens after this point in time. Perhaps you will be able to access the photograph that will be posted in the chat to have a look for yourself if you haven't already. But the photograph shows Mr. Henry basically struggling against 3 police officers in the background and also being in somewhat of a chokehold, while all other people who are participating in the lineup are smiling. And that after that photograph is taken, I'm sorry, to back up, 11 victims of Mr. Henry were present at the lineup that day in May of 1982, including 6 of the victims named in the indictment that proceeded with the 1983 trial. And 4 or 5 of our plaintiffs in our AB and Henry decision from 2025 were there. Mr. Henry chose to introduce that photo at his trial in 1983, and ultimately there was a finding by the Court of Appeal in 2010 that this was one of the valid grounds of appeal. Basically, the instructions to the jury about what specific inferences could be drawn from this were problematic for the conviction itself. After the lineup occurred, Mr. Henry was released shortly thereafter. And then, unfortunately, on June 8, 1982, there was another victim referred to in the 2025 decision as IJ, was sexually assaulted under similar circumstances. And then in late July of 1982, IJ identified Mr. Henry in a photo lineup, leading to his rearrest and the commencement of the criminal proceedings. There was a preliminary hearing that took place in October and November of 1982. And during that time, Mr. Henry was represented by counsel, and he was committed to stand trial on 17 counts involving 15 different complainants.
And so the preliminary hearing for many of the victims was probably their first experience with the criminal justice system. And as discussed in our case from our clients, their first, I think, realization of sort of how alone they were in that process. One thing that I think people, frankly, often don't understand in the criminal process is that the Crown lawyer is not the victim's lawyer. The victim is not a party to that, and they are not represented. They are merely witnesses. And from our client's perspective, it was their first sort of shocking realization about how alone they were in that process. All 5 of our clients testified at the preliminary inquiry, and then the jury trial began in February of 1983, which, as Emma mentioned, involved Mr. Henry representing himself. He had previously at the preliminary inquiry been represented by counsel, so any cross-examinations there were done by counsel, but at the trial it was a different story. Some of the counts have been severed by the time of the trial, and so it proceeded on a 10-count indictment involving 8 different victims, including the 5 of our clients. Again, at the criminal trial, 4 of our 5 clients testified. One of them had given her evidence on the preliminary inquiry. She then had gone back to her home in the eastern United States and was dealing with the trauma of having been a sexual assault victim and the passage of somebody very close to her, so she was not able to come back to Vancouver for the criminal trial. And her preliminary evidence was used at trial for that purposes. I say that mainly because in 2015, when this was all being uncovered in the Charter Damages trial, the headline in the Vancouver Sun was that one of the victims did not, words to the effect of, did not even bother to attend the criminal trial. as though it was a choice of the victim and it was her who was failing the system, as opposed to the victim being in an impossible situation as a 22-year-old woman who had experienced this kind of trauma and doing her very best in the circumstances. From broader social perspective, it's an interesting, I suppose, time when this happens, because the trial is happening in February of 1983, and it's later in 1983 that Canada's criminal laws are modernized. And I'll give the caveat that neither of us are experts in criminal law. We're civil litigators who have had to learn a great deal of the criminal law through this proceeding. But it was later in 1983 when the laws were changed to include sexual assault. Previously, Emma referenced the charge was rape, and rape was confined to a male perpetrator and a female victim. It was confined to penile vaginal penetration. It was confined to being outside of marriage, because there was no marital rape at that time. And of course, this was only 42 years ago now. So the laws significantly have been updated, and were updated immediately after Mr. Henry's trial. It's also the case that it was in between these events and Mr. Henry's trial that the charter was enacted, and the court started reviewing the constitutionality of laws from a charter perspective. So following the 12-day trial in the early part of 1983, Mr. Henry was found guilty on all counts. Mr. Justice Gropper was the trial judge, and in November of 1983, there was a further hearing where again, 4 of our 5 clients had to come back, give evidence again about the impact on them of these assaults, to be subjected to cross-examination by Mr. Henry again. And ultimately that led to Mr. Justice Gropper's decision to declare Mr. Henry a dangerous offender, which results in an indeterminate sentence. In the course of that, our clients felt comments made were certainly intimidating and threatening, as to how they received them through the cross-examination and comments by Mr. Henry, the dangerous offender proceedings. And so at least as of the end of 1983, our clients, I suppose, felt they had the comfort of knowing that the man convicted of their sexual assaults was being incarcerated, as from their perspective, forever. Then things picked up again in 2006.
And Emma has already touched on this, but a special prosecutor was appointed to review Mr. Henry's convictions in 2006. And there is a hearing before the Court of Appeal. And in 2009, there's a release of Mr. Henry pending the outcome of the appeal. In October of 2010, the appeal is allowed, and there's a conclusion that Mr. Henry had been wrongfully convicted, and he is acquitted on all counts that he was originally found guilty of. The court found that these multiple errors had undermined convictions. And when I say multiple errors, that was the misdirections to the jury and jury instructions regarding the inferences that could be drawn from Mr. Henry's refusal to participate in the lineup, the instructions on identification evidence, and the failure to order severance of the various counts of indictment. And as Emma has also said, right after this ruling of the Court of Appeal, Mr. Henry then goes on to commence a civil action for breach of his charter rights and seeking charter damages against the province of BC, the city of Vancouver, the police, and the Attorney General of Canada in relation to post-conviction review applications. There is then a trip to the Supreme Court of Canada to confirm the availability of charter damages claims against the Crown in its prosecutorial capacity. And then there is a 2015 trial lasting 3.5 months held before Chief Justice Hinkson in late 2015. As this trial is going on, IJ, one of the plaintiffs that we represented, she was scheduled to testify at this trial as a witness for the city of Vancouver, addressing the issue of Mr. Henry's factual guilt. However, shortly before IJ comes to give her testimony, the city reached a settlement with Mr. Henry. The city was the only defendant to plead that Mr. Henry had committed the 10 sexual offenses for which he had been convicted. And so following the settlement with the city, there was no party to the litigation that remained that would be allowed to call evidence from the victims to argue that Mr. Henry was factually guilty. And this, frankly, and in my opinion at least, and I believe that it's been voiced over and over again, is one of the things that ultimately led to the civil litigation that we were involved in, because the victims were denied their right or victims were denied any participation in the proceeding. In the reasons for judgment by the court found that the Crown's failure to disclose relevant information in its possession before the 1983 trial was a breach of Mr. Henry's charter rights. And then further, that pursuant to section 24(1) of the charter, the court then awarded Mr. Henry substantial damages, $7.5 million in charter damages, along with $530,000 in compensatory damages, and just over $56,000 in special damages. The issue of Mr. Henry's factual guilt or innocence was not before the court, and no ruling was made on that. As Kevin has mentioned already, during this time, Mr. Henry's case attracted significant media attention. Local newspapers covered the trial regularly. There was a W5 episode dedicated to the case, and there was also a book published called Innocence on Trial: The Framing of Ivan Henry. The overwhelming public narrative was one of an innocent man wrongfully convicted. From the reopening of the case in 2006, the victims were voiceless. And in the aftermath of Mr. Henry's 2015 trial, and after not being able to give evidence about his factual guilt following the settlement of the city, 5 of the 8 women who had been complainants in the original 1983 trial embarked on the lawsuit that would ultimately result in the decision that we're here to speak about today.
When we talk about the victims being voiceless, I mean, that term often gets used, but in this context here, so there's first a special prosecutor who's doing the review, and the victims were not contacted for an appreciation of what their evidence was and what they had to say about the picture. In the Court of Appeal, and as lawyers, you know, the Court of Appeal is not a new trial. This is not unexpected. They don't hear witnesses, but they had no role to play in the Court of Appeal proceedings by their very nature. And then in the charter damages trial, there was the hope and the expectation that they were going to be called, or at least some of them were going to be called as witnesses to give their version of events, even though they weren't parties to that litigation. And then, frankly, it felt as though the rug was pulled from underneath them in the late stages of the trial due to the settlement with the city, and the question of factual guilt being removed from consideration there. And so in this context, voiceless quite really, it truly meant that they had no opportunity anywhere along that tortured history to give their version of events. And this is important because these are all very real people. We had the good fortune to come to know them well. And Mr. Henry has always been the main character in these proceedings. And so the victims often get lost along the way. But they are all remarkable, strong women in their own right. They're all very different. They were strangers to one another, brought together by sharing one horrific commonality of being sexually assaulted. And so I just want to touch on briefly who each of them are, as documented in Madam Justice Gropper's reasons for judgment. So A.B. was born in England in 1948 and moved to Vancouver in 1969. Her sexual assault happened on May 4th, 1981, when she was 33 years old. At the time, she was a respected professional working at a local investment company and living on her own in a ground floor apartment on 16th Avenue. In the middle of the night, a man broke into her apartment and sexually assaulted her at knife point. CD was born in 1960, so on the date of her assault on February 21, 1982, she was 21 years old. She was attending university, living alone, which is the common refrain, in a studio apartment on West 7th. A stranger broke into her apartment at night, claiming he was looking for someone named Valerie, then threatened to slit her throat from ear to ear and sexually assaulted her. EF was born in Montreal in 1948, moved to Vancouver in 1976, and was working for ICBC in its early days. She was living alone on Carolina Street near 5th and Fraser. On March 9, 1982, the man broke into her apartment, again saying he was looking for Valerie, threatened to cut her, and sexually assaulted her. 9 days later, GH was living in her apartment on Osler Street near Oak and Southwest Marine Drive when on March 18th, a man broke into her apartment and sexually assaulted her. She was 22 years old at the time, also a university student. And lastly, IJ was an American born in the Eastern United States in 1959. She had just graduated from university that summer and moved to Vancouver to work at a local theater company just for the summer. She moved into a basement suite in the 400 block of West 17th. It was the first time she had lived alone and was within the first couple weeks of her living there. On June 8, 1982, a man broke into her suite and claimed he was looking for Debbie, who had ripped him off and then proceeded to sexually assault her. She was 22 years old. None of these women needed to spend the last 8 years dealing with this civil litigation. They were victimized over 40 years ago, and they are now between 65 and 77 years old. I say that it took remarkable courage and bravery and tenacity to pursue this because they felt it was important to correct the historical narrative, to get at the truth, and for the role it would play for other victims. It was an extremely complex case for a whole host of reasons. Practical complexities included just the sheer volume of material. Given the earlier trial, the preliminary hearings, the criminal trial, the dangerous offender hearings, the special prosecutor's review, the Court of Appeal procedures, and then the multiple month charter damages trial in 2015, the sheer volume of material was astronomical. We were navigating a case with 5 different clients who, as I mentioned, would be strangers to one another, who are individuals who might have different takes on things, might see things and have different priorities, might see things differently and have different priorities. And so that all had to be navigated. From a legal standpoint, the complexities were several. It included the treatment of the earlier judicial findings. So Mr. Henry was arguing that the victim's civil claim was an abusive process because we were in their submission seeking to relitigate prior judicial findings. The main prior judicial findings that they were saying we were seeking to relitigate involved, although not exclusively, but largely involved the prior conclusions on the identification evidence, which the Court of Appeal had said in different terms that it was unreliable or not strong, or said that it had been so polluted as to render in-court identification highly questionable and unreliable on a reasonable doubt standard. All of that comes back to the overarching burden of proof. And it is trite to say, but it is important to never lose sight of the fact that criminal cases are a review of what the Crown is able to prove beyond a reasonable doubt. And that's a difficult concept to quantify or to put a number on, but it's something that our courts have said is much closer to absolute certainty than the civil standard, the balance of probabilities. And so when we are speaking with a sexual assault victim, particularly one where the Crown has decided not to proceed with charges or where there's been an acquittal, it's just so important to keep in mind that the criminal procedure is not necessarily to get at the truth, so to speak. It is about whether or not the Crown can prove beyond a reasonable doubt that the accused committed the essential elements of the offense. And I think oftentimes victims see the failure to be able to meet that very high standard, which is derived from society's decision that we'd rather let 10 innocent men, 10 guilty men go free than one innocent man go to prison, that we will always err on the side of innocence, that it can cause a victim to believe the failure to achieve an acquittal means that they were wrong, or that they had failed, or that they had lost, so to speak. And it's important to not lose sight of how important that burden of proof is and how different it is in the civil context. And so the findings of the Court of Appeal on the strength of the identification evidence were always made in the context of whether at the trial in 1983, the evidence led by the Crown was sufficient to prove guilt beyond a reasonable doubt. To say something is unreliable can't be divorced from the standard of proof that is being brought to bear on that evidence. So fortunately, the abusive process application was dismissed. It was found that we were not relitigating findings, and that the plaintiffs here were entitled to bring to court for the first time, frankly, the question of whether or not it was more likely than not, whether on a balance of probabilities, Mr. Henry was the man who had sexually assaulted them. There were other significant legal issues that simply don't come up in civil litigation often, involving similar fact evidence, so evidence related to other crimes and the extent to which that could help support a finding that that Mr. Henry was the man who committed the offenses. How we approach the identification evidence, those are questions that there's significant jurisprudence on in the criminal realm, but the framework from those criminal cases often is not easily adapted to the different standard of proof in civil cases. There's a legal scholar who's now a justice in the Ontario Court of Appeal named David Pachaco, who wrote an article long ago on approaching hearsay, and talks about how the rules of evidence that civil litigators deal with are hand-me-down rules of evidence that are often ill-fitting because they're developed in the criminal realm and can't easily just be taken from there and dropped into the civil context, mainly because of the different burden of proof. There were also all sorts of procedural issues where criminal law has developed to handle sexual assault cases, and there really hasn't been any corresponding changes in the civil realm. And Arena had to deal with a number of applications in that regard.
So in our trial, or even before the trial, in the context of this litigation in general, we had made applications for an order that any records of the plaintiffs be produced in accordance with criminal code provisions. And I'll tell you in a moment what those are. And we also asked for an order that each plaintiff have access to a counselor whose records need not be produced at all. Now, generally speaking, of course, everyone would like to have their privacy respected, and it's sacred to them with respect to medical records of any nature, and especially counseling records in the context of sexual assault. In this particular case, the plaintiffs were extra sensitive to production of any records due to the nature of the assault, and also due to their fear of Mr. Henry and his ability to identify and locate them, having gone through the ordeal in 1982 and 1983 with the preliminary inquiry, the trial, and the dangerous offender hearing. They were quite concerned about his remarks. and him, as what they call it, coming after them. Additionally, the plaintiffs were obviously going through a lot of trauma in the lead up to the trial and in the course of the litigation in general. And they needed a safe space in which to discuss their trauma and de-stress and the stress with a counselor. So the purpose of seeking to have a counselor's records not producible at trial was to provide the plaintiffs with a safe space for support. And obviously, the litigation process would lead to reliving and re-traumatization on several different occasions. And the plaintiffs needed a counselor to talk to about this, but not be concerned about those records being disclosed and ending up in the hands of Mr. Henry and his legal team, and also not being subject to cross-examination with respect to those records. It's not that the plaintiffs had anything to hide, but it's very difficult to have any meaningful form of counseling if there's a concern in the back of one's mind about how this will reflect on them in the legal process. With respect to what the criminal context offers in terms of protections for victims of sexual assault, there was a lot of amendments historically that dealt with mandatory publication bans that prohibits publication of the evidence of a, for example, complainant's sexual activity. There is also a general prohibition on production of complainants or witnesses' personal records. And there is comparable, that this applies in the context of trial as well as preliminary inquiries. Are we having any?
Just a comment that you speak a little louder.
Sorry,
So the
well,
interpreters can hear.
I will certainly try to keep my voice up or maybe come a little bit closer to the camera, although my face is very large there. There were a bunch of different developments, as I said, through the criminal code, but there was also the development of the Canadian Victims' Bill of Rights in 2015, where the privacy and identity protection of victims was heavily emphasized. Through the development of these legislative protections, the Supreme Court of Canada then was required to interpret and confirm the constitutionality of such provisions. And that led to the development of what we now call the Mills regime about production of records of a victim of sexual assault in the context of criminal proceedings. And what the court said there is that what is required is there to be a balancing of constitutionally permissible balancing of accused interests and the accused interest to make a full defense against the privacy rights of the complainant. These sections essentially mean that the accused has to apply for production of any of the victim's personal records if indeed they think that they would be relevant to an issue at trial, or to the witness's ability to testify, or their legal competence to testify. So it's a burden that they have to meet as opposed to the other way around, which is what happens in the civil context. With respect to what an accused has to show in order to gain access to a victim's records is that not only that the records are likely relevant to an issue in trial, but the record can't be introduced simply to show that there was some psychiatric or psychological treatment that the complainant was seeking, or that the record relates to the subject matter that is under criminal proceedings, or that the record may disclose a prior inconsistent statement. What there does need to be is that there's a relevant issue or an issue of competence addressed in the records. Unfortunately, as we've said multiple times, these safeguards are not present in the civil litigation arena. The reason for the protection of the victims is outlined clearly in the criminal code as well, which is that there is obviously potential prejudice to the person's dignity and right to privacy of any person to whom the records relate. But there's also societal interest that needs to be balanced in encouraging the reporting of sexual offenses, and society's interest in encouraging the obtaining of treatment by complainants of sexual offenses. So while we applied before the trial to for certain medical records to and during the trial for certain medical records to only be produced if the criteria under the Mills regime were met, the court denied the plaintiffs that relief because the civil law has simply not developed in a similar way, and legislative change is likely required in order to move in that direction. And so far, we are left with the production of clinical records in a similar fashion in the sexual assault case as we are in other matters of personal injury, such as a motor vehicle accident, which just doesn't seem to be the way that things should be.
Yeah, I mean, the judges are really the ones who interpret and apply the rules that are designed for them to interpret and apply. And so when we brought these applications, in particular with respect to how records should be produced and the nomination of a counselor that they could see, knowing that those records would not subsequently be produced and essentially used against them in the litigation. I think the courts were receptive, but saying essentially, but we don't have the tools to do that. And that's why we're saying that there needs to be some legislative change to the rules of court or otherwise that would allow them to treat production of records differently. So we, on the application to nominate a counselor to who the plaintiffs could see during the course of the litigation, we were relying in large part on comments from Justice McLaughlin, and prior to being Chief Justice McLaughlin in the Ryan case in 1997, which involved a young victim where the wrongdoer was her psychiatrist. And in the case, the psychiatrist was applying for production of his victim's subsequent clinical records. And in the context of that, Justice McLaughlin said, coming up on 30 years ago, comments on the victims of sexual abuse often is suffering serious trauma, which left untreated may mar their entire lives. Justice McLaughlin commented on it being widely accepted that it is in the interest of the victim and society that such help be obtained. The mental health of the citizenry, no less than its physical health, is a public good of great importance. Just as it is in the interest of the sexual abuse victim to be restored to full and healthy functioning, so it is in the interest of the public that she take her place as a healthy and productive member of society. This the Supreme Court of Canada recognizing that we need to do everything possible to allow people, particularly sexual abuse victims, to get the treatment that they need. And in the absence of a regime that allows for that kind of thing to happen, one of two things can happen. Either it can simply mean that the victim does not get, well, three things: does not get the treatment that they need, gets treatment but isn't able to really access it, because you're not going to be able to properly access treatment, always thinking that whatever I say, whatever notes are made of it, that could subsequently be used against me. Or three, that somebody will simply not be able to seek their rights for fear that their private information would subsequently be used against them. And any one of those is something that society should be concerned about. In the application to nominate the counselor, it proceeded in front of Justice Skolroot, who's now our Chief Justice. And what Chief Justice Skolroot said in that case was that it is not open to the court at this stage, by which he means that there isn't a legal framework for him to do it, to order that certain unnamed treatment providers be precluded from giving evidence at trial. That it is a decision for the trial judge or for the judge called upon to determine a properly constituted privilege application. So what he's saying is that he can't prospectively order that future records won't have to be produced. And the problem then being our inability to tell our clients, to give them any assurances that, yeah, they can get the treatment they need and not worry about it. What he does say in the next paragraph is, while it is less than the plaintiffs seek, I think that the one assurance that the court can give to the plaintiffs based on the laws that currently exist, referring to the Ryan case, the disclosure of counseling records will be ordered only where clearly necessary and then only to the extent necessary. So that is helpful, and it does represent a real concern for the issues that were being raised, but it still doesn't give the individuals the assurance really needed to get the treatment hoped for. There were also applications about presence of Mr. Henry for proceedings.
That's right. In the criminal context, again, things are very different than in the civil context. But what we had applied for before the trial itself was the exclusion of Mr. Henry from the examinations for discovery of our plaintiffs. Because again, it would be difficult for them to provide testimony in a meaningful way if he was there in a very small room with them. Fortunately, there was an indication that he did not intend to appear, but that order was granted that he would be excluded from the examinations for discovery. But when it came to trial itself, we were prepared to make an application for his exclusion from the trial while the plaintiffs testified. Of course, every party to any proceeding has the right to be present for the entirety of the case against or for them. And so such an order is generally unusual in the civil context. The criminal code now protects the complainant in a sexual assault trial from being personally cross-examined by the accused, but also there are a lot of other measures that can be implemented so that this person, the victim, can testify either outside of the room through CCTV or in some other manner that is more acceptable to them to be able to provide the evidence that is necessary for the proceeding.
I think one of the other challenges from our perspective as lawyers is frankly how to approach the needs of our clients who are, as I said, 5 strangers to one another previously, 5 totally different individuals with different perspectives and different views on perhaps how things should be approached. And we, as civil litigators, really have no meaningful training in what's now often referred to as a victim-centered approach. I think we were very fortunate in this case by having these 5 remarkable clients who made that job much easier than I think it typically would be. But it is something that we had to do our best to try to navigate as people who normally argue things in court, but don't necessarily have that kind of training. I don't know if Emma, you wanted to touch on that?
Yeah, thanks, Kevin and Irina. I think a couple of things that I'll pick up on of Kevin and Irina's kind of reflections really on the procedural challenges and the logistical challenges that arose over the course of preparing for the trial and conducting the trial. The first is to underscore Kevin's point that in my experience too, the plaintiffs in this case are tremendously intelligent and articulate women who are so much more than what happened to them in a bedroom, and who have a capacity and have had from the outset of my dealings with them, I'm sure long before that, the capacity to understand exactly what the legal system has been doing to them and the ways in which strategically their voices have been excluded. But life is complicated, and it's also true that these women and other potential victims of Henry suffer continuing trauma as a result of what was done to them, and that trauma has a direct nexus with the subject matter of this trial, and that presents challenges for the legal system and certainly for their lawyers. There's a way in which the arc of this case from the very outset reflects both the evolution of Canadian law and the limits of that evolution. So one of the things that always struck me in the early days when I was working with the plaintiffs was that in 1982, 1983, when the women were testifying in preliminary hearings and in trials, Henry had charter protections, but they did not, because Section 15 of the Charter didn't come into effect until 1985. And so their case, at least with respect to Section 15, if not with respect to their Section 7 rights, was complicated by that frankly, historical injustice in the introduction of charter protections. The second thing I think that's really reflected in the procedural creativity that Kevin and Irene really had to kind of engage in over the course of the litigation is the ways in which the adversarial lens, which is imposed through an appeal to laws processes, narrows the complexity that exists in life at large. So the narrowness of the adversarial lens, the rules of evidence and procedure, we know, and feminist legal theory certainly demonstrates, as does critical race theory, that legal systems tend to deal especially poorly with the complexity of people's lives and perspectives when those people have been historically underrepresented within the law's hegemony. And so the underprotection, for example, of the women plaintiffs' capacity to access counselling in a space which was protected from the litigation is absolutely of a piece with historical underprotection of women through and in the law. So that dialectic that exists between the court rules, between the rules of evidence and a legal culture that prizes adversarialism, I think reflects the challenges of shifting legal culture towards a more trauma-informed footing. And that shifting to a more trauma-informed footing will continue to be limited. And I think Kevin and I really confronted those limits to the extent while legal rules and rules of evidence continue to present barriers to trauma-informed lawyering. I think that's really what you confronted at times throughout the process. The second thing I'll pick up on is Kevin mentioned the case of MA versus Ryan and specifically the kind of factual scenario of that case. And I would like to say just a little more about that case because I do see it as frankly, a continuing harm within the legal system that I agree with your calls, either legislatively or as a matter of common law, really needs to be addressed. So the plaintiff MA in the MA versus Ryan case was bringing a civil suit against her former psychiatrist, Dr. Ryan, for sexual assaults conducted within the context of the clinical relationship. She was a teenager at the time that those sexual assaults took place. By the time the case came to trial, she had a new psychiatrist, Dr. Parfit. And again, we see here this nexus of the source of the trauma, which is both legal and also very much connected with the supposedly therapeutic context and the betrayal of that therapeutic context of psychiatric work. And Dr. Ryan made an application for access to Dr. Parfit's records of that therapy. When the case came to the Supreme Court of Canada in the judgment, famous judgment written by Justice McLaughlin, as she then was, the court confirmed an earlier case called Brunke, the application of a common law approach to protecting confidential records, which is generally called the Wigmore approach by lawyers. Broadly speaking, it has 4 steps, the first 3 of which focus on the legitimacy of the claim to privilege, and the last of which purports to balance that claim to privilege against the interest in getting at the truth of the litigation. The way in which that 4th balancing step is characterised in MA versus Ryan, I think this is exactly the challenge you ran into when you made that early application, really sets up a dynamic in which the privacy of those who seek to access counselling or other support services and insulate that from litigation will always yield to what the court calls in very grandiose terms the truth-seeking function of the litigation. Broadly speaking, the game is rigged. The truth-seeking litigation function of the litigation will always prevail over those claims to privacy and dignity. And I think that's where our understanding of the trauma of sexual assault and the needs of sexual assault complainants has come a long way in the 30 years since MA versus Ryan was decided. And it's one place where I think we really are overdue for a reform, whether legislative or common law in that legal space. The second thing to observe from my vantage as somebody who thinks and writes about criminal law, although I'm not a practitioner, is I am struck by the ways in which the civil rules haven't been updated to reflect some of the developments, such as the Mills regime. But I'll also say that the grass is not always greener. And so one of the things that we've observed as the protection of complainants against oppressive cross-examination in sexual assaults has been kind of put forward is, for example, that complainants are called back to testify multiple times about the same things in criminal cases now in a way that we know to be re-traumatizing. And so we're not there yet, I think, either criminally or in the civil realm, but there's no question that the civil realm continues to wear hand-me-downs, and even then, not all the hand-me-downs, and continues to underprotect sexual assault victims who are seeking legal remedies.
So I think we're wanting to save a few minutes for questions. So just to sort of wrap things up, Irina, did you want to say a few words?
Sure, I think one of the things that I always come back to is these 5 brave women who I had the honor of meeting and spending a lot of time with, and I think I speak for Kevin when I say that it was an honor to represent them. But I wanted to note that they have gone through so many decades of ordeals with ups and downs that have thrown their lives into absolute turmoil. And they did recognize that Mr. Henry's charter rights were infringed and that he did not receive a fair trial. But they still knew at the same time that this was the man who assaulted them. And they chose to go on this very long and very emotionally, practically, and financially expensive journey so that they can find some measure of justice for themselves. But this was not their only motivation, and they were all very clear about this, because they really wanted to affect societal change for all victims of sexual assault. This was crucially important to each and every one of them, and they wanted other people to hear their story. They wanted to have their story told in their own voices, not through the voices or perspectives of others who didn't have the details or the full story. But most of all, I think that they wanted their story of perseverance to be a driving force for A, change in the legal system, but B, also an inspiration to others who might find themselves in these very horrible circumstances of being a victim of sexual assault and having to go through criminal or civil proceeding. And their story is a story of resilience, and it should be, and it certainly is an inspiration to me and other people who might encounter anything similar, and that they should come forward and not give up. It was a very, very long journey, and I thank them for coming forward and taking us along for at least a part of it.
And just to end on that, our civil justice system has all sorts of challenges and improvements that could and ought to be made. I would also say, I suppose, in its defense, though, in this circumstance, ultimately, as challenging and daunting and at times terrifying as the process was, I hope that it was also at times empowering, because it really was the victim's chance here for the first time to be parties, to be represented, to be able to tell their story in the way that they wanted to tell it, and to ultimately get at the truth in that. I wanted to end with a line from one of our clients who is an extremely talented writer, and in her evidence had given is spoken of a sample of writing or a poem that she had written about her experience in the preliminary inquiry as a very young woman, totally on her own. And she said in that, in a lengthier piece, it's remarkably powerful. She says, "I am thankful that I walked out of that gray courthouse bathroom and I marched what was left of myself alone into the room where my almost murderer was, and I showed him that I stayed alive." And I think it took a tremendous amount of courage for them to do that back in 1982 and 83, and to persevere some 42 years later through this case. So those are my comments. Are there any questions?
Thank you all so much for such a fascinating dialogue and such an important conversation. Would you like me to help with the Q&A, or would you like to handle it? Okay.
If you could please, Sarah, that would be great.
Yeah, happy to. So we have a number of questions that came in, so I'll kind of just work down them in chronological order. And for those of you who submitted questions in French, I've done my best to translate them. If I butcher your questions, I'm incredibly sorry. So we have the first question that came in pretty early on in your presentation that says, "Thank you for this presentation and for your important work. Was the settlement with the city in the charter damages case a lowball settlement calculated to remove the question of factual guilt or innocence in this case?" And then they
No,
ask
so
if something is known about the details of that settlement.
yeah, so we only know about the details of settlement because afterwards there was an application in front of Chief Justice Hinkson about whether that settlement should be deducted from the award he made as against the province. And the conclusion was, yes, it should be deducted so that there wasn't double recovery. So we know from that the settlement was $5.15 million. So no, it wasn't a lowball settlement.
Thank you. And the second part of that question is, were any efforts made to address the resulting gap in the case following the settlement, such as amended pleadings?
So the challenge there was an earlier application that involved the question of res judicata, which is two parties to the same proceeding being prevented from relitigating an issue. So the province had been a party. So the province is the crown, essentially, in this context. The city is the police, and the province is the crown. And so the province had been a party to the acquittal in 2010. And so because of an earlier finding by Chief Justice Hinkson, and also the fact that they simply hadn't pleaded initially factual guilt, there was no party to raise that issue. There was the application brought by an organization called Rape Relief immediately after the settlement to try to have what's called an amicus, basically some outside person to raise an issue so that that evidence could be heard and so that the issue could be decided. And that application was denied. And the context of it, in fairness, was that it was at the very end of the trial. I think all of the evidence had concluded. And so procedurally, it would have been incredibly difficult. I don't know how that would have played out, but the point is that efforts were made. But at that point, it became sort of a legal impossibility, I suppose.
Thank you for that. There are a couple questions hopping in around citations for the cases, both one you referenced to regarding interests of society for victims to get help, and a few more referenced throughout. I know, Emma, you sent me some links and I'll happily repost them. If there are others you have, we can also distribute them after the webinar. That's just for sort of everyone listening. All right, the next question. It seems the plaintiff in this hockey team trial is being subjected to all kinds of questions around her sexual history and behavior, such as drinking, the night of the alleged assault. I thought victims had more rights at this time and that this would not be allowed. And the person apologized they may not have heard everything. They are in a busy workplace, but if you could shed either initial light or more light on how they are still able to do this and what it will take to change in the future.
So what I would say is that I should be very clear in our caution that neither Irina nor myself are criminal lawyers, and any comment I would have on a case that I've only followed in the news as other people had and why that's been allowed would be ill-informed. So it's not something that I'm really comfortable going into. I'm not sure what the details are, frankly. I don't know, Emma.
I'm happy not so much to speak to the detail, but perhaps to speak to the dynamic that is being reported, I think, in the media fairly clearly. That's really the kind of scenario that I had in mind when I said at the conclusion of my remarks that things haven't come as far in the criminal law as perhaps people from the civil litigation side might consider. My own research and that of scholars such as Janine Benedette, Isabel Brandt, Elizabeth Sheehy shows very clearly that notwithstanding Elaine Craig at Dalhousie has also done important work on this, notwithstanding the existence in the criminal law of protections that are intended to prevent lawyers from asking intrusive questions about the sexual history of a complainant, for instance, that stereotypes and myths about sexual assault complainants continue to flourish in the criminal legal system. And it continues to be the case that trial judges will allow defense counsel to ask those questions on what appears at times to be fairly thin reads with respect to claims about the relevance of that behaviour to the charge that's been laid against the accused. So I should be clear, I'm not specifically commenting on the evidence in the hockey case that's currently playing out. There may be good basis for it, but certainly it's a very well documented tendency within the Canadian criminal legal system that those questions continue to be asked, notwithstanding the existence of statutory protections.
Thank you so much, Emma. That was very well said. This comes back to the compensation piece, and I know you may not be able to fully answer it, but a few questions that came in there were asking if Henry had to return the money that the court awarded him and if the victims or survivors were given some financial compensation.
So no, what I'll say is that the judgment is for each of the victims. The damages were assessed at $375,000 for each of the 5 victims, and that's the order of the court that is currently under appeal. And I think that's the extent of what I can get into at this point.
But to answer directly, no, Henry was not told to return any compensation. So the decision of the civil case that the plaintiffs had proved on the balance of probabilities that Henry was their assailant doesn't disturb the conclusion that was made by the earlier case that Henry was wrongly convicted on the basis of prosecutorial misconduct and police misconduct. Those two things are both true.
Yeah, so that's exactly right. And the basis of the $8 million plus award to Mr. Henry was the finding that hasn't been disturbed, that his charter rights were breached in the 1982, 1983 criminal proceedings. The finding that by Madam Justice Gropper in 2025, that he is the one who committed those offenses is totally separate and apart from that.
Great, thank you. Moving a little bit away from the compensation piece, a question came in that is, was the Canadian Victim Bill of Rights used in any other way than therapeutic records, such as the right for information or participation?
I'm not sure that I fully understand the question, but if it's meant to be, was it used in the context of our litigation, then no. It was just referenced in our applications for the protection of records, because it obviously forms a basis that you can rely on in other contexts, and also forms the basis of the broader societal context for why victims should be entitled to protection of their privacy and their records.
Yeah, I think we were generally relying or pointing to its recognition of the privacy rights of victims in why the orders we were seeking should be made, but it's not something that we could directly rely on, so to speak.
Thank you. I think that very well answers the question. We have another related to sort of the application of laws and rights here. So someone asked, did these survivors have their rights considered under the Canadian Charter of Rights and Freedoms? You mentioned that Section 15 came into law later, but in more recent proceedings were they applied?
So not directly, and the reason for that is that it is government that owes charter rights to individuals. So when if in a hypothetical situation where the victims were bringing a claim against the government for not adequately protecting their rights, then their charter rights would inevitably be invoked. But in a claim against an individual, as this claim was against Mr. Henry, it's not directly raising the breach of our client's charter rights. However, as Justice McLaughlin discusses in Ryan and is widely accepted now, the law needs to develop consistent with charter values, which includes the right to privacy and such. So it was, the charter and our client's charter rights was raised in the context of that, but not a specific claim, for example, for damages for breach of their charter rights.
I wonder if I can add to that. Thank you, Kevin. By kind of rewinding the tape even further to Henry's original proceedings for charter damages and claim to have been wrongly convicted, because the history of the complainant's charter rights in that context is very interesting, actually. So in 2012, the complainants applied essentially for a recognition by the court that their charter rights were implicated in Henry's proceedings. And in an interlocutory stage, Justice Gopper of the BC Supreme Court really appeared to accept that. So wrote a judgment that raised questions about the BC Attorney General's capacity to fully represent the complainant's charter rights, given that they were also serving as defendant against an allegation of misconduct on the part of the prosecutor. And signaled that he believed that the complainants should have independent legal representation, essentially, within the process. The BC Attorney General refused to fund that independent legal representation when the complainants sought that funding. And subsequently, Chief Justice Hinkson, in the kind of merits phase of the trial, really took a very different view. And so essentially took an approach to Henry's application for damages that entirely excluded any consideration of the complainant's charter rights. And so this is another place where we see that hand-me-down phenomenon, because I think in a criminal case, it's very well established that both the accused's charter rights and the complainant's charter rights need to be considered in finding a procedural way forward. Justice Gopper seemed to understand that at an interlocutory stage in the charter damages case, but that really got sidelined within Chief Justice Hinkson's process. And I'm quite critical of that in the Supreme Court law review article that I mentioned at the outset of my remarks.
Great, thank you. And for those listening, I did reshare those links so you can get to that article again as well. I wonder if that's a good way to kind of wrap up the discussion. I'm looking through the chat and you seem to have addressed most of the questions. Actually, one just came in, I think is actually the perfect way to stop, and then we'll hand it back to Margaret. Is the general impunity of Crown prosecutors causing these types of victim rights violations in many cases, and is there any consideration for remedy of that?
Honestly, that's a
Tough one.
question for a criminal practitioner rather than myself, so I'll pass on that.
Yeah.
Fair enough.
What I will say is that we, as a criminal law academic, we do see cases where prosecutors fail to enforce or make arguments about the procedural rights of victims. But we also see cases where trial judges fail to recognise the operation of those rights. And so I'm thinking of the case of R versus Barton, for example, sometimes known as the Cindy Gladue case, which went to the Supreme Court of Canada in 2019, as being one where really all participants failed to recognise that the complainant had rights within the process that needed to be honoured. I wouldn't want to generalise about all Crown prosecutors by any stretch, but I do think that problematic examples arise.
Thank you so much, everyone. All right. Well, unfortunately, we weren't able to get to all of the questions, but we got to the bulk of them. I still want to give us a little bit of a chance to wrap up. So thank you all so much for such a thoughtful discussion. And Margaret, I'll hand it back to you. Margaret, if you are talking, you're on mute. Perfect.
Oh, hello there. Yes, no, it was a problem with, never mind the mechanisms I'm working with. Anyway, yes, gosh, I want to conclude the webinar by first thanking all three of you for the excellent presentations. Very well received here. And you clearly achieved what I think were the objectives of the webinar by first assisting us to understand the legal and social complexities of not only the Henry case, but of the two court processes in terms of different procedures, different standards of proof and the meaning of that, and how those differences really do impact outcomes differently. So that was one point that I took to heart, because I am now much more fully aware of those kinds of differences and their impact. Also, I appreciated what I took throughout here and what you were indicating about the value of the women's voices and how important that was, not only for, as you mentioned, I believe, Kevin, for their own feeling of empowerment, but the reality of that being what is most appropriate in these kinds of cases. And also, I thought that more generally, it referenced for me the very evolution of women's rights, legal protections. And I got the sense at the end here that the promotion of what you deem to be more victim survivor-centered legal practices, if you put it that way, was one example or one idea of how it might be achieved in more just ways to have those voices heard in the court. So I would like to thank you again. I think that there are some other questions. I actually had two, but that's okay. I can, I'll send them along. They were obviously very important. But yes, this has been great. And yes, I have to stop because I'll start going off on a tangent here. So thank you both, all three, very much for that. So yes, I think I should probably move on, if I may, just quickly to acknowledge and thank others also who participated, including the interpreters, Violaine Tournay and Claudine Bonon, who did a great job. I'm sure that was quite challenging in terms of trying to follow along with a written script that way. They did very well. And for others obviously from UWO Privat Center itself, with Katrina Scott at its helm, with the personnel associated with the Awareness to Action Project for tech assistance and support, including Barb, Laura, Jessica, and others. And finally, I will not leave out the co-director, Sarah, Dr. Sarah Yursich, who did a superb job, I think, of stick handling and co-directing. So thanks to all of you, and I would wish you a good rest of the day unless there are other further comments to be made. Thanks.
Thank you.
Thank you for having us.
Hey,
Thank you.
thanks very much. Okay. Bye.